Call the meeting to order. This is the Standing Committee on Justice and Human Rights. Today is Tuesday, November the 30th, and this is meeting number 39. Just for the record, this meeting is televised. You have before you the agenda for today, and we're dealing with two items. First of all, we're beginning a review of Bill C-48, an act to amend the Criminal Code and to make consequential amendments to the National Defence Act. And secondly, we'll move to a review and consideration of the Supplementary Estimates B. The Minister will join us for the second hour of our meeting. So back to Bill C-48. To assist us with our review, we have with us two witnesses. First of all, we have an official from the Department of Justice, namely John Giokis, counsel from the Criminal Law Policy Branch. Welcome back.
Thank you.
We also have with us Lieutenant Colonel Bruce McGregor, who's Director of Law and Military Justice Policy and Research for the Department of National Defence. Welcome to our committee.
Thank you.
Now, I understand, Mr. Giokis, you've got some introductory comments, and once you're done, we'll open the floor to questions.
Thank you, Mr. Chair. I'm here today because I understand that the committee has requested that officials provide an overview of Bill C-48, an act to amend the Criminal Code and to make consequential amendments to the National Defence Act. And as the Chair has indicated, I'm here with Lieutenant Colonel Bruce McGregor from the Office of the Judge Advocate General. After my presentation, I will respond to any questions that you may have with regard to the Criminal Code amendments set out in this bill, and Lieutenant Colonel McGregor will respond to any questions you may have with regard to the consequential amendments to the National Defence Act. That being said, as a preliminary matter, let me begin by saying, and as I'm sure you're aware, the punishment for first and second-degree murder in the Criminal Code is life imprisonment, with the possibility of applying for parole after a period of parole ineligibility determined under Section 745 of the Code. That period is 25 years from the time an offender is brought into custody for first-degree murder, and it's also 25 years for any second-degree murder where the murderer has previously been convicted either of another domestic murder or of an intentional killing under Sections 4 and 6 of the Crimes Against Humanity and War Crimes Act. The parole ineligibility period for all other second-degree murderers is a minimum of 10 years. That being said, sentencing judges are already authorized under the Criminal Code under Section 745.4 to set a parole ineligibility period for second-degree murderers that may range anywhere from 11 to 25 years. In making this decision, judges must have regard, and I'm quoting here from Section 745.4, to the character of the offender, the nature of the offense and the circumstances surrounding its commission, and to the recommendation, if any, made by a jury. In essence, the bill before you today proposes to amend the Criminal Code to authorize a judge to impose multiple periods of parole ineligibility on convicted multiple murderers to account for each murder victim, and to use exactly the same criteria in making his or her decision in this regard. Let me be more specific. Bill C-48 would amend Section 745.5 and related provisions of the Criminal Code to authorize a sentencing judge to impose on an offender sentenced for more than one first or second-degree murder or any combination of first and second-degree murders, a separate 25-year period of parole ineligibility for the second and for each subsequent murder. As mentioned, in exercising this authority, the judge would be required to have regard to the character of the offender, the nature and circumstances of the murders, and any jury recommendation. In essence, we are proposing exactly the same criteria as appear in Section 745.4 to ground this new authority. However, the sentencing judge would also be required to state orally and in writing the basis of any decision not to exercise the authority being proposed in Bill C-48. However, the key point is that these additional 25-year periods of parole ineligibility would run consecutively to the period of parole ineligibility imposed for the first murder. And as I mentioned, that period will depend on whether it is a first or second-degree murder and whether the judge has used the authority in Section 745.4 to set the parole ineligibility period for the first murder at anywhere between 11 and 25 years. Coming into force of Bill C-48 will occur on a date to be fixed by order in Council, and to ensure that jurisdictions are aware of the nature of this proposal, the Department of Justice will begin consultations with them as soon as this bill is passed into law. That being said, we are now open to any questions that you may have on Bill C-48.
Well, thank you very much. Given the fact that our time is limited due to fire alarm during question period, I'm suggesting we go with 5-minute rounds. Is that acceptable? Acceptable? All right, we'll start. Who's going for the Liberals?
I've got
5 minutes.
Thank you. I thank you so much for your presentation. I have 2 questions. Since the death penalty was abolished in 1976, how many offenders sentenced to concurrent life sentences for multiple murders have received parole? And my second question is, since 1976, what, if any, is the average sentence served by convicted multiple murderers prior to being granted parole, if indeed any such offenders have been granted parole?
Thank you for your question. Unfortunately, I can't answer your question in terms of the stats since 1976. I can give you some numbers. The best numbers I have, if you'll just give me a moment. The numbers I have are that as of August 2009, that's last year, there were 4,311 federal offenders who had committed first or second degree murder. Of these, 457 have more than one murder convictions, more than one murder conviction. While I can't answer your question about the length of time they spend in custody, I can tell you that as of August 2009, only 26% of multiple murderers had been paroled. This is compared to over 40% of single murderers. In terms of the precise questions you've asked, I will undertake to get that information for you and bring it back to the committee.
In that case, could you also undertake to determine whether or not you have the data as to whether or not the 26% that had been paroled as of August 2009, whether any had had their parole revoked, and if so, on what basis? What were the charges for or reasons for revoking parole? And if there's any time left, I would turn it over to my colleague, Mr. Lee.
Minutes.
Yeah, just two questions. This bill and the penalty arrangements under it don't connect in any way, I take it, to the penalty for treason, for high treason. It's
no.
Not at all. Okay. And secondly, in your remarks, you were describing the second period of consecutive ineligibility, and you described it as 25 years. Could it, in fact, be the case that a second period of parole ineligibility could be less than 25 years but greater than 10? In other words, the first given parole ineligibility period, let's say hypothetically, was 20 years in a second-degree murder?
No, the proposal as set out requires a mandatory 25 years for the second and any subsequent murder.
No, then that definitely answers my question. There's no flexibility here. No matter what the first period of parole ineligibility was, a second one, under this legislation, a second one must be a 25-year ineligibility period.
Yes, that's right. It is based on the existing provisions of the Criminal Code
Yeah.
in Section 745.
Okay. Thank you.
Thank you. We'll move to Monsieur Menard for 5 minutes.
What we are currently discussing, if it's a case where a person who has already been convicted of murder undergoes another trial for a separate murder that they would have committed, or could it also be a person who had committed a double murder during the same event? For example, in Quebec this year, we had a doctor who killed his 2 children. So, no, according to the bill, all murders must take place after the coming into effect of this bill, but the murders don't have to occur during this at the same time. There could be a murder and then later on a separate murder, so whether it's one trial or 2. What is important is that all murders occur after the coming into effect of C-48. Well, yes, I understand that very well. What I want to know is, we had 2 incidents in the same year in Quebec that were family cases, and both of them, where a surgeon killed both of his children because his wife left him, and it's not something that you can understand, but that's what he did in the aftermath. And the other case was a family that was very poor, that tried to do everything, and ultimately the family decided that the whole family would die, so they prepared medication and distributed them to the members of the family. The father and the 2 children died, but the woman survived, so she's now accused of all 3 murders, charged with all 3 murders. So under those circumstances, multiple murders, would the period of parole ineligibility be consecutive in those cases? Because when I read the bill, I'm under the impression that it's always concerning a trial for someone who's already been convicted of a murder and then is subsequently convicted of another murder. No, as I said, that's possible. It could happen that someone commits a murder and then in a different case commits another murder. Yes, I understand that. That's fine. Yes, it could happen, as in the case that you mentioned, there would be 3 murders within a single event, but the convictions are consecutive, and it could be, for example, that this person would receive a parole ineligibility period of 10 years for the first murder, because it's a second-degree murder. There were certain circumstances taken into consideration, and it's understood. If a judge, however, decides, because it's up to the judge, and that is very important, if the judge decides to add consecutive parole ineligibility periods, each period would be a 25-year period. So in the case that you quoted, the person could have received 10 for the first murder, but 25 for the second and 25 for the third, at the judge's discretion. So if there's one single judge who heard the 3 murder charges, 3 cases, yes. In fact, this makes me think that the majority of multiple murders are indeed committed in circumstances by people who are desperate. Yes, I agree. we have very few examples of serial killers in Canada, a handful. The great majority are murders that take place at the same time, often a family or at work. These are people who are suffering from problems, certainly. That is why it is it is discretionary. Thank you.
For 5 minutes. And you're sharing your time with Mr. Deckard?
Yes, thank you very much. Just one or two questions to be absolutely clear. First of all, regarding the issue of retroactivity, and apart from the specific wording which I see, let's just start with under the existing wording, if someone commits a murder and is sentenced and then commits another murder, would this legislation permit a judge to impose a consecutive parole ineligibility with respect to the second murder?
Yes, if both murders occurred after coming into force.
All right, let me repeat that, because that isn't actually what I was trying to ask. I was just a bit distracted. So what I mean to ask is, if a murder is committed before the section comes into force and results in a period of parole eligibility, and then the same individual commits a murder after the section comes into force, will a court be permitted to impose a consecutive parole ineligibility with respect to the second murder?
No, but there are already rules in the criminal code which deal with that situation. There's a combination of effect between the Corrections and Conditional Release Act and the Criminal Code, which would require that the second period of parole ineligibility be added to the first, and added to what is left of the first. In other words, the clock would start running again. So if somebody commits one murder prior to coming into force, and I presume they've been, from your example, that they've been captured, convicted, and are serving a prison sentence, and
Correct.
they can commit another one. If they've served, say, 10 years of that first parole ineligibility period, the law automatically adds another 25. So they would serve 35 years.
Yes.
That happens automatically right now.
But if it was not such a lengthy period, if it was 1 year, then it would be 26.
That's right.
And is that by virtue of the wording of this Act, or is it by virtue of some other wording in the Criminal Code or Corrections Act?
Well, the example you gave me was a murder before coming into force and one afterwards. So in that case, it's the interaction of Section 120.2 of the Corrections and Conditional Release Act and Section 745 of the Criminal Code.
Thank you. And secondly, I just want to be very clear. If an individual at the present time commits one murder, and a week later commits another murder, and a week after that commits a third murder, is there any discretion in the court or in a well, it's the court that sentences, so any discretion in the court to impose consecutive parole ineligibilities in such a case under the present regime?
No, not under the law as it stands now.
All right, thank you. I'll give the rest of my time to Mr. Deckard.
Mr. Deckard?
How much time do I have, Mr.
You have 1.5 minutes.
Okay, thank you. Gentlemen, thank you for being here this afternoon. I think it's kind of interesting that we're discussing this bill today when, as you probably know, earlier today, Clifford Olson applied yet again for parole. That's a person who committed 11 heinous murders that we know about and received one life sentence. And it seems to me that we as a society need to light a candle for every life that's taken illegally and in these terrible circumstances such as that case, and we need to respect each victim, and this bill may be one way that we can do that. I'm happy to report, by the way, that Mr. Olson has been denied parole again, but I feel for the families of his victims who had to appear again today. I'd like you to tell me why. We've heard a lot from our friends on the other side of the room here that Canada has a longer than average incarceration for murderers anyway, so why do we need to do things like this? I wonder if you could describe for us why you think this legislation is necessary given that case.
Thank you for your question, Mr. Deckert. The rationale for the bill was set out in the speech of the Honourable Daniel Petit in his remarks on November the 15th, and they were very much to the effect of what you've just said. I don't believe I could add anything more meaningful to them.
Okay, thank you. Why will sorry, are we out of time? Another round. Thank you.
We're going to go to Mr. Murphy for 5 minutes.
When we start asking DOJ officials what their policy slant is the day that we should switch roles. I take the security, though. I wouldn't mind being a DOJ person. But I respect your answer on the policy question. I have a question. It's back to the hypothetical of, I think we're all trying to get our head around the discretion that might be used. Double murder, same circumstances, clearly first degree. If the judge decides that on the first murder, the person should not be eligible for parole until 25 years, that's first degree, how is he or she going to separate the second murder, which is the same, so the person's automatically ineligible for parole for 50 years in that situation? If he uses, I don't know how he could use the discretion in one case and not the other. Like you're saying on the second murder, he could say, I'm using my discretion and not granting, or I am granting parole eligibility, and equating the two murders as the same. To me, the problem might be that the discretion is there. That's good. I remark, by the way, why it isn't there in S6. I wonder why it isn't, because we're dealing with the similar part of the code. That's Payne Hope and so on. That's, I guess, one question. But the second question is, would we not be better off if we gave the judge a little more discretion on the number of years? In other words, a judge might look at those two instances and say, 25 years, yeah, he might be on the borderline as to whether he wants to go 50 years. He might very easily say 35, but we have this choice between second degree 10 and first degree 25, and unless I'm wrong, the judge can't, you see it on TV in the American courts, they can just sort of, I think, pick a number out of the air, and you're not eligible for parole for 36 years. In Canada, am I right, you can pick 10, you can pick 25, in the case of two murders, you can pick 50, but you can't pick between 25 and 50 in two first-degree murders, as far as I see it. I wonder if it might be good to have that sort of sliding scale, because if you're going to give discretion, you should give it. You shouldn't sort of say, well, you got a choice here between 25 and 50, or 75, or whatever the case may be. I think in three-person murders, again, we got a little far afield, the choice between 25 and 75 is pretty large as well. But between 25 and 50, there might be a judge who thinks this guy is 40, he should pay, no question. Each murder is equal in the eyes of the law in terms of a denunciation, but I've got a choice between 25 and 50, and heaven knows somebody might rehabilitate themselves. Yeah, I just asked for your comment about whether we should have something in between. And the comment on S6, by the way.
Let me deal with the second comment first. The Criminal Code already states in Section 745 that in the case of a first-degree murder, it's a mandatory 25 years. And if somebody commits another first-degree murder, it's a mandatory 25 years, and so on. The issue right now is that those 25 years are served concurrently. What we're doing in the case of first-degree murder is giving the judge the discretion to make the mandatory period of 25 years consecutive. So this is already set out in the code. In the case of second-degree murder, which is the example that you also mentioned, it's also set out in Section 745 that in the case of a second-degree murder where somebody has already been convicted of another murder, whether it's first or second degree, it is also an automatic 25 years. So the 25-year period is already established in the Criminal Code. And all that Bill C-48 does is allow a judge to make the periods consecutive based on criteria that judges are already using to make a decision that is similar in kind, namely whether to extend a minimum 10-year to 25 years in the case of a single second-degree murder.
You don't see that between 25 and 50, in the case of a double murder, that a judge might want to have some leeway. You don't see that. You see it, oh, it's already there, it's 25, should be 25 or 50. That's what you're saying. That's the discretion a judge has under this bill. I'm not saying it's a bad thing. I'm just saying there isn't much in between 20, well, there's 25 between 25 and 50.
Well, there is perhaps a...
First degree, no, but just stick with 2 first-degree murders, okay? At the same time, it's either 25 or 50 under this law.
That's right, according to the discretion of the judge.
You don't see any need for, okay, well then you're not going to bend on that. Could you tell me why S6 wasn't considered, why discretion wasn't considered to be kept in for S6? Why here, why not S6?
Which discretion are you referring to, sir?
The judicial, so much time?
Mr. Murphy, we're actually not dealing with S6, as you know, and I think we should focus our comments and our questions on this particular bill. Anyways, you are out of time. We're going to move on to Monsieur Menard.
Mr. Giokas, I have a problem, and I'm trying to understand here. Someone is convicted of a second-degree murder, and the judge sentences them to life in jail with a possibility of parole after 10, 12, however many years. So we all know about that. But someone is found guilty of 2 murders that are not premeditated. Okay, so did I understand correctly when my colleague asked the question that if the judge can impose the parole ineligibility period of 25 years, so that for the first non-premeditated murder, let's say he's served 15 years, but for the second non-premeditated murder, it would be 25 automatically. Is that what I understood? Yes, that's right, that's clear. Therefore, during a single event, the person commits 2 murders, and it's the same deal, 2 murders, and they could have a heavier sentence, a longer sentence, because it's life, etc. But if it's 2 murders in the second degree, there could be a 15-year period, an eligibility period, and then a second one of 25. Yes, that's possible if the judge decides that. But can the judge decide that it would be less? No. In the case of the second period of ineligibility, no. So in the second period, he has no discretion, he has no choice. If he goes under 745.21, the new section, or 745.51, so if he gives 2 consecutive sentences, it's 25 years, there's no discretion. Well, no, as I explained, it's set out in section 745, paragraph B. In the case of a second murder, when there has been a previous murder, it's a 25-year period. So what we are doing is giving the judge the discretion to make them consecutive, the second period consecutive. We base these measures on the existing provisions of the Criminal Code, but the only thing that has changed is that we are also giving the judge discretion. Okay, for example, if we had the case of Colonel Williams, there are 2 murders, so in the current situation, it would be 25 years. But if the judge had some discretion, he could add a second 25-year period. That's what I'm understanding? Yes, if they had happened after the coming into effect of this legislation, the judge could have given him 50 years rather, 25 for each murder. which he could not do in the current situation. No. So that's exactly what the situation is now. There was a problem within the criminal code, and I know that you don't want to get into a political discussion. You can't talk about the short title, for example, of this bill. But currently, everyone agrees that the judge does not currently have that discretion. The person can commit 4 murders, and it's only 25 years. So now we could allow the judge to exercise his discretion. But if he chooses to exercise that discretion, it's 25 years more. That's correct? That's what's in the bill? He cannot make it less than 25-year periods because of 745B, right? Okay, thank you. That's clear. Thank you. Oh, just one. Do I have some time left? 15 seconds. 15 seconds. Is that the same thing for the military under Section 149 of the National Defense Act?
We have, from the military justice system, we see no reason to diverge from the government's position on this for the sake of the military. So it is consistent.
Okay. Merci.
Mr. Deckard for 5.
Thank you.
I'd just like to start by just correcting the record. Mr. LeMay mentioned a certain individual. Russell Williams has been stripped of all rank in the Canadian Forces, and I think Lieutenant Colonel McGregor will agree with me. So I think we should probably correct the record.
Translation.
Okay. Oh, perhaps it was. I apologize. That's what I heard in translation.
Mr. Deckard, the translation wasn't working. He didn't hear what you said.
Right.
Can you repeat?
Yes. Russell Williams has been stripped of all rank in the Canadian Forces. I just wanted to point that out and correct the record of that matter. Mr. Jokas, could you tell us why consecutive periods of parole ineligibility are not made mandatory under this legislation for multiple murderers?
It's to ensure that we are in conformity with the Charter.
Okay. I guess that's a short and sweet answer. Thank you. What are the cost implications, in your view, of housing and providing health care to an increased number of aging federal inmates, which may result from this legislation?
There will be no cost implications that are foreseeable for the next 25 years.
Okay. And beyond that, if Clifford Olson needs a walker, perhaps I personally would be happy to contribute to that. What impact will longer periods of incarceration, in your view, have on an inmate's incentive to pursue rehabilitation and demonstrate good behavior?
I'm unfortunately not in a position to be able to comment on that. And I'm not trying to avoid the question, but it's not my area of expertise. I would suggest that corrections officials be asked that question.
Okay, fair enough. Under this legislation, could consecutive periods of ineligibility for parole be imposed on offenders who have already been convicted of multiple first and second degree murders?
All murders have to occur after the coming into force of the legislation. So somebody who's already a multiple murderer has the benefit of the law as it stands today.
I see. Okay. Thank you. I have no further questions.
Is there anyone else on the government side to complete the 5 minutes? Nobody? We'll go back to Mr. Murphy.
Indication to Mr. Deckard's question, or an answer to one of his questions, you said to make it comply with the Charter. I wonder, I didn't quite get the full answer on that. I assume then there was a full review of this legislation for Charter compliance.
We always review legislation for Charter compliance. It's a legal requirement on the minister.
But what specifically was done to make this proposal Charter compliant? In your answer to Mr. Deckard, I'm not sure I was clear.
I'm not able to divulge, for obvious reasons, legal advice provided to the minister. What I can say is that it is our belief, based on advice that has been provided to the minister, that this legislation is Charter compliant.
In Now, Mr. Chairman, you don't want me to mention any other legislation. Can I mention the code? Okay, rhetorical.
Yes, you may.
Thank you. We're a free democratic society. It's wonderful. There is in some of the life imprisonment aspects the offense of treason. There's no application for treason in this law whatsoever. I think Mr. Lee had asked that.
No, because I don't believe we have anybody in prison for treason now, and it's hard to envision multiple acts of treason.
Well, I think that, and I don't want to go back to other legislation, but other legislation we've looked at did throw in high treason. And was it just sort of because it's in the same part of the life imprisonment section, or because, like you say, it's not a heavily used section?
The high treason provision appears in S6, the Faint Hope Bill, and that's because people who are convicted of high treason also benefit from being able to apply for faint hope relief.
I have a few minutes, and Mr. Lee has some
Mr. Lee,
time.
Mr. Lee, please go ahead.
Just one question. In the first criminal act involving murder, this is a hypothetical I'm laying out here. In your remarks earlier, you did make reference to other types of homicides. I think you did. But as I read the section, it always refers to murder. So these sections wouldn't apply to a case where, for example, there had been a manslaughter in the first offense.
No.
And a murder in the second. These sections would not be applicable there. It has to be a first or second degree murder, followed by a first or second degree murder, or one of the...
An intentional killing under the War Crimes and Crimes Crimes Against Humanity and War Crimes Act.
Yes, okay. Thank you very much, Mr. Chair.
Thank you. Any other questions? None? Well, Monsieur Menard? Oh, Monsieur Lemay?
Insultez-moi pas.
Insult me now. We can see now that the judge has to justify his decision under 745.51. Would his decision be appealable by the Crown? That is to say, if the judge decides that he is not going to add on the consecutive sentence, is his decision appealable? Yes, and depending on the Crown and the defense lawyer. Well, I'd be surprised that the defense lawyer decide to appeal, but the Crown might under those circumstances. So what section? Well, in both clauses, under Clause 3 of the bill, the Crown can appeal, and under Clause... All right, okay, 745. Clauses 2 and 3, under Clauses 2 and 3. Is there a particular process that the judge has to go through? Does he have to hand down a written decision, or can it be an oral decision? Either one. Thank you.
Has now joined us. Mr. Comartin, did you want to do one 5-minute question?
No, I'm fine.
You're fine? All right, then we'll thank our witnesses for appearing, and your testimony will be helpful as we continue consideration of this bill. What we're going to do is suspend for a couple of minutes. I'd like members to stay at the table while we do that, because there's just some committee business I wanted your direction on. We suspend for 2 minutes. Now to supplementary estimates B for the years 2010, 2011, and you should have the estimates before you. We welcome back our Minister of Justice and Attorney General of Canada, the Honourable Rob Nicholson, and accompanying him is an official from the Department of Justice, Mr. Miles Curvan, Deputy Minister of Justice, also Deputy Attorney General of Canada. So you know the drill. If you've got an opening remark, and then we'll open the floor to questions. Mr. Minister.
Well, thank you very much, Mr. Chairman and members of the committee. I'm pleased to be here on Supplementary Estimates B for the Department of Justice. Mr. Chairman, as you know, our government was elected on a promise to tackle crime, and we've acted decisively on this promise in order to ensure the safety and security of our neighborhoods and communities. En tant que ministre de la Justice,
as the Minister of Justice and Attorney General of Canada, I am determined to ensure that our justice system be truly fair.
Law-abiding Canadians want us to act, and our government believes, as we stated in the speech from the throne, that the law must protect everyone and those who commit crimes must be held to account. Canadians want a system that delivers justice. And to achieve that goal, we have pursued a wide range of reforms to strengthen our criminal law. And I think our record speaks for itself. We've passed legislation to establish mandatory prison sentences for gun crimes, toughen sentencing for dangerous criminals, and we've raised the age of protection from 14 to 16-year-olds to better protect young people from adult sexual predators. We've also succeeded in eliminating the 2-for-1 credit for time spent in jail awaiting trial, a practice which disproportionately reduced prison sentences for some violent offenders. Police associations, victims groups, and indeed all provinces and territories have expressed their support for that legislation. Our government has also passed legislation to increase penalties for murders and reckless shootings connected to gangs and organized crime. Now, any murder connected to organized crime activity will automatically be considered first degree and subject to a mandatory sentence of life imprisonment without eligibility for parole for 25 years. In addition, there are many pieces of proposed legislation that are currently before both houses of Parliament. Legislation that will strengthen the justice system to the benefit of law-abiding Canadians, with a particular emphasis on protecting children and showing respect and compassion to the victims of crime. I mentioned that none of this would have been possible without the invaluable assistance, advice, and commitment that we have received from the employees of the Department of Justice. I take this opportunity to thank them for all their dedication and hard work. Monsieur le Président, comme vous pouvez en témoigner.
Mr. Chairman, as you can attest, our commitment to protecting Canadians remains as strong as ever.
Recently, I was proud to announce our legislation to protect Canadians from property crime and auto theft, which, as you know, just recently received royal assent. The Tackling Auto Theft and Property Crime Act will help crack down on property crime, including auto theft and trafficking in property that is obtained by crime. Auto theft has a huge impact on Canadians and threatens the safety of our communities. This legislation will help disrupt criminal enterprises and send a clear message to gangs and organized crimes that if you engage in auto theft, there will be serious consequences. And once this new law comes into force, law enforcement and courts will have better tools to tackle auto theft and the entire range of activities involved in the trafficking of all types of stolen or fraudulently obtained property. Another part of our fight against organized crime, Mr. Chairman, can be found in the new set of regulations we enacted to strengthen the ability of law enforcement agencies to fight these sophisticated criminal activities. These new regulations identify as serious offenses such organized crime activities as illegal gambling and specific prostitution and drug-related crimes. The fact that an offense is committed by a criminal organization makes it a serious crime. These regulations will help ensure that police and prosecutors can make full use of the tools in the criminal code that are specifically targeted at tackling organized crime, and are better able to respond to organized crime and ensure that penalties are proportionate to the increased threat to public safety that organized crime activities present. Mr. Chairman, we also welcome this year the coming into force of the legislation to fight identity theft, which, as you know, is a fast-growing crime in North America. Our new law provides police and justice officials with important new tools, including 3 new core criminal code offenses targeting the early stages of identity theft or identity-related crime, obtaining and possessing identity information, trafficking in identity information, and unlawfully possessing or trafficking in government-issued identity documents. All of these offenses are subject to a 5-year maximum prison sentence. Our government believes Canadians are entitled to have their identities and other valuable information protected to the highest degree possible. Now they have greater protection against identity theft, and police are better equipped to stop these crimes before they are committed. We're also standing up for the victims of white-collar crimes, which can have a devastating effect on individuals and communities. Our government has listened to the concerns of victims of fraud, and we are helping them to seek restitution and ensure their voices are heard in sentencing those who have harmed them so profoundly. To that end, as you know, we have introduced legislation that cracks down on white-collar crime and fraud and increases justice for victims. Our legislation would make jail time mandatory at least 2 years for fraud over $1 million. It would toughen sentences further by adding aggravating factors that the courts can consider. Mr. Chairman, in the speech from the throne, we paid particular attention to the need to protect the most vulnerable members of our society, our children. Sexual exploitation of children causes irreparable harm, and our government is committed to helping prevent sexual offenses against children by ensuring that adult sexual predators receive sentences which reflect the extreme seriousness of their crime. We have proposed legislation that would establish mandatory prison sentences for 7 existing criminal code offenses, such as luring, sexual assault, and aggravated assault. As a result, conditional sentences, including house arrest, would no longer be available for any of these offenses. The proposed legislation would also increase mandatory prison sentences for 7 sexual offenses involving child victims, such as possessing and accessing child pornography and sexual exploitation. As well, Mr. Chairman, the creation and distribution of child pornography are appalling crimes in which children are brutally victimized over and over again. Our government has recently proposed a mandatory reporting regime across Canada that will require suppliers of Internet services to report information about Internet child pornography. This will strengthen our ability to protect our children from sexual predators and help police rescue these young victims and prosecute the criminals responsible. Our government has also shown its concern for the victims of multiple murderers and their families. We firmly believe that families of murder victims should not be made to feel that the life of their loved one doesn't count. This is why I tabled a bill in October that will permit judges to impose consecutive periods of parole ineligibility for multiple murderers, thus putting to an end sentencing discounts for these horrible crimes. While there can only be 1 life sentence for an offender who commits more than 1 murder, the parole ineligibility period, 25 years in the case of a first-degree murder, could be imposed consecutively for each subsequent murder. In addition, we will continue to seek the elimination of the faint hope clause from the criminal code. By saying no to early parole for murders, our government hopes to spare families the pain of attending repeated parole eligibility hearings and having to relive these unspeakable losses over and over again. I was saddened earlier this month that there were a number of several unnecessary amendments to this important piece of legislation, including the replacement of the short title of the bill. As a result of these unnecessary amendments, Bill S6 will be delayed, and I'm disappointed to report to victims that this is not already the law of this country. But again, Mr. Speaker, we remain committed. I would like to take this opportunity to thank honourable members for the work they do. I plead with them not to make unnecessary amendments to bills that only slow down bills for which there is widespread support and consensus among the people of this country. Mr. Speaker, we remain committed to helping victims of crime. We committed $52 million over 4 years, starting April 1st, 2007, through the Federal Victim Strategy for a package of programs, services, and funding to help the federal government and the provinces and territories respond to the needs of victims. This, of course, includes the creation of the Office of the Federal Ombudsman for Victims of Crime. And I was very pleased recently to announce that the Government of Canada would provide over $5 million over the next 5 years to support the development of child advocacy centres across Canada. I visited the one in St. Catharines, Ontario, which is, of course, next door to my constituency, and I couldn't help but be impressed by the work that is being done there. It's being done in a number of municipalities across Canada, and this is something that we all must encourage. Our government remains committed to supporting victims of crime through existing programs, and will continue to work with stakeholders to create new initiatives such as the child advocacy centres I just mentioned. Nevertheless, Mr. Chairman, victims of crime have indicated their primary unmet need is access to information about the justice system and the services available to them. To help meet this need, the Government of Canada is reaching out to victims of crime through the recent Victims Matter campaign to raise awareness and let victims know what resources are available to them. The funding for this campaign comes from a separate Treasury Board allotment for the government advertising for the fiscal year 2010-2011. This investment is above and beyond the funds already allocated to the Victims Fund. The campaign's goal is to increase awareness and uptake of the services and programs available to victims of crime, and therefore, by extension, increase the use of the Victims Fund. The results of the campaign so far are showing that we are reaching Canadians and raising awareness. As of November 27th, the Victims Matter website had received more than 1.1 million hits, with close to 40,000 visitors averaging a length of visit of more than 5 minutes, which suggests visitors are finding plenty of content worth reading. Mr. Chairman, the safety and security is a priority for our government, and we will not apologize for our commitment to victims and law-abiding citizens. En terminant, Monsieur le Président.
In conclusion, Mr. Chairman, I would like to express my appreciation and thanks to you and your committee members for the important work that you do.
The government's work to respond to the needs of Canadians. The funding that we have received has brought results, and I will do my utmost to ensure these funds continue to be spent wisely and in the service of Canadians. And we will continue to deliver on our promise to tackle crime and stand up for victims. We will continue to listen to the views on Canadians, how we can improve our criminal justice system and make all our communities safe. Thank you very much, Mr. Chairman. I look forward to any questions you may have.
Thank you, Minister. We're back to 7-minute round, and Mr. Murphy, I believe you're going first, so you have
Chair.
7 minutes.
Thank you, Minister, officials. I'm going to draw on my questions from, I guess, pages 170 through 181 of the supplementary estimates. I have some specific questions. I can't help, though, in passing, give a bit of a remark back to you, Minister, that the government's been in power close to 5 years, and to blame everything on the Liberal-dominated Senate. Well, oh, wait a minute, that's not the case anymore. Or the changing of short titles that go way beyond the actual reach, even the effect of legislation, is a little mysterious and a little hyperbolic. But let's not get caught up in political debate. Let's get down to the figures. You've been in office 5 years. You are now starting to appropriate money for some of your grand visions. And if you look at page 180, I appreciate as a preface to these specific questions on expenses that you had a separate allocation from the Treasury Board with respect to a campaign regarding victims of crime. I appreciate that that is separate. But within these figures, can you tell me specifically with the third item, funding to support victim services, to increase national support for missing persons investigations, for that item, for the next, the item two lines down, the funding for increased support for victims of crime, for the creation and enhancement of the child advocacy centers that you referred to. Those two sums are $2.5 million and $1.3 million. Can you tell me whether any of those sums allocated, appropriated, are for advertising, for publicity, for promotion? That would be one question. The second question, because I want to give you lots of time, Minister and Deputy Minister, to answer. The second question, Minister, I've been at Canadian Bar Association meetings when you've made it very clear that transfers to provinces regarding legal aid are just that. They're transfers to provinces. And almost across the country, your fallback position is, I can do nothing with what provinces do with their allocation generally with respect to ensuring that there's adequate legal aid in the provinces. I think that's a constitutionally sound argument, Mr. Minister. But in this item under transfers, if I understand it correctly, you have transferred or taken a transfer of $2 million to provide immigration and refugee legal aid funding for provinces and territories. It seems to be exactly what you say you do not do as a government, which is to transfer money directly to provinces for specific legal aid services. I wonder if that's a breakthrough. I wonder if it's a good thing. I wonder if it's something that you're mandated to do as government under citizenship and immigration. I just wonder what it is and why it's such a large sum, and finally why it's being transferred from citizen and immigration. Did they do it before and covered it in their budget? Did they not do it before? Is this something new? So those are kind of three general expenditure questions. Minister?
That's a lot, Mr. Chairman, here.
I left you lots of
with
time.
respect to my problem with you changing the titles of the bill, it delays the bill. Everybody wants, I think for the most part, I mean, I got it unanimously passed to getting rid of the faint hope clause. The bill has already been passed by the Senate. If you make minor amendments to it, you know, if you're uptight about the name of the bill, it means that it would have to then go back to the Senate. That's the system of government we have. And so when I'm trying to explain to victims that there is a general consensus that we want to get rid of the faint hope clause, I have to tell them, say, look, we've got a couple of amendments now at the House of Commons that will delay the bill. That's the point that I've made. With respect to the increases, the money for advertising comes from separate funds. The money that is going into the, you mentioned among other things, the child advocacy centers. Again, that money is available for groups across Canada to make applications to put together a child advocacy center or to assist with one that may be already up and running. That's what the money goes for. In addition, the money to support victim services and violence in Aboriginal communities, again, that is new money that has been announced to assist in the pursuit of those who have victimized Aboriginal women. That being said, it's important to get that message out. That's not what this money is being used for, but we have, I mentioned the education and the advertisements that we are doing because we want victims and individuals to take up these programs and to become aware of what they are referring to. Now, with respect to legal aid, yes, there are transfers to the legal aid with respect to criminal and, as you pointed out, with respect to refugee system. Yes, we do that. Most of the questions that have been directed towards me with respect to the constitutional separation or the arrangements that have been made with the provinces and territorials relate to civil legal aid. And as I indicated to them, that prior to 1995, when I was an MP here in the early 90s and I was the parliamentary secretary to the Justice Minister, I of course watched and looked each year to ensure that money was being transferred from the federal government for the purposes of civil legal aid. This would help people, for instance, on matrimonial disputes. Now, in 1995, I was not a part of that, as you I'm sure are aware, it was rolled over into the Canada Social Transfer. And so what I've indicated when I've been at the Canadian Bar Association and other forums, saying, yes, I watch every year with the budget, and am pleased that each year the Canada Social Transfer has been increased each year, because I know, therefore, the opportunity then exists for provinces to assist in the area of civil legal aid and indeed other worthwhile projects. But it is sometimes put to me, say, why don't you go back to having a line item? And as you could probably guess, there are a number of provincial jurisdictions that aren't welcoming that and encouraging us in that direction.
I wasn't clear on your answer, actually. I am on the civil legal aid thing, and it's a point that you and I may agree on, actually, that we should have dedicated civil legal aid funds. I think you set a good example by doing that with this type of transfer. In any event, where I don't agree with you, and just to be clear, I don't agree with you on very, very much, Mr. Minister, but it's hard for me to understand from your answer what amount of the two previous questions I asked, and I want to take too much time, but the Aboriginal community support for missing persons investigations and the child advocacy centers, it's very unclear to me in your answer whether any of those line items, 2.5 million, 1.3 million, were spent or are to be spent on advertising and promotion. I mean, how much of 1.3 million is actually going to bricks and mortar and staffing of child advocacy centers? How much of the 2.5 is actually going into Aboriginal communities to hire people, investigators looking for missing people?
Well, I all to go in, Mr. Murphy. As a matter of fact, none of the money has been spent yet on child advocacy centers, because I only announced it, I think, about 3 weeks ago in Toronto. And so at the time, I encouraged those who are active in this area of child advocacy centers that, yes, there will be applications. I want you to take advantage of this, because this is the first time the federal government has been involved with something like that. I mean, up to these points, these child advocacy centers have been relying on either municipalities, service groups, bake sales, this sort of thing. I mean, I'm pleased that the federal government is coming forward with money. So, again, there has been no money of that has been, in direct answer, to advertising. I don't want it to be part of advertising. I want it to be in terms of the applications of these individuals. And as I indicated, advertising is of the type that I did refer to, coming from my colleagues, the Minister of Health and other members, is something separate from that.
Thank you. We'll move to Monsieur Menard for 7 minutes.
Merci. Thank you. Mr. Minister, we're here to talk about your request for supplementary budget estimates, and I don't think I heard anything in your presentation about the budget. So I would like you to enlighten me, perhaps. I understand what your legislative agenda is. You put a great deal of emphasis on the comfort that victims would get by saying that the people who have victimized them will be serving longer sentences. But victims generally express other needs that represent costs, however. So do you have in your budget, in this supplementary estimates request, anything in mind to satisfy the other needs of victims, other than the satisfaction of seeing their tormentors serving longer sentences?
I didn't mention too much about the budget. Believe it or not, Mr. Menard, when I've been here in the past, over the last 4 years, most of the questions had nothing to do with the budget, and that's, of course, at the, and Mr. Comartin, you are an exception to that, but most of the questions are about general policy or specific issues that relate to the justice portfolio. I'll give you an example that are specific to victims. The whole area of child advocacy centers that I indicated that I made an announcement of about 3 weeks as part of the supplementary estimates. I feel very strongly about that, because these child advocacy centers are set up to assist children who have been victimized, children who will be witnesses within the criminal justice system. And what they do is they provide sort of a safe, reassuring setting for children to make their case, and so prepare them for either the questioning or the possible court case that will follow. And so I feel very strongly about it. As I indicated to you, I had a first-hand look at what they were doing in St. Catharines, Ontario, which is next door to my constituency. I was very impressed by that. So, yes, that is directly in the supplementary estimates, as well as the support for victim services as they relate to Aboriginal Canadians. You'll know that there was an allocation in the last federal budget on that, and that is reflected as well in the supplementary estimates. So you're quite correct that there are greater funds being allocated for victims in this country within the supplementary estimates, and again, that's appropriate, but of course that goes hand in hand with those programs that I've already indicated to you. I talked to you about the Victims Fund that we initiated in 2007. Of course, that will continue for this year as well.
We don't have very much time, but I note that the example you gave once again concerns the legal proceedings and victims. So I think that victims need other assistance, not that it's a bad idea to help them with any legal proceedings, but I would like to hear whether or not it's your responsibility to see to the victims receiving the psychological support that they need, for example, to get through these experiences.
Maybe you misunderstood what I was saying. Helping children get through this and bringing in a wide range of support, everything from psychologists to others, helping children to get through this is a very important part of our program to assist victims. And I would encourage you and others, if you're aware of groups that want to make applications under the victims funds that we have set up, that by all means to come forward. There have been some very impressive applications that have come forward. And again, the whole area Child Advocacy Center just happens to be the newest area, but I think these are very important because they send out the right message that we want to support those individuals who become involved in one way or the other with the legal system of this country. And in addition, quite frankly, I've been impressed over the years in my discussions with provincial authorities. They take this matter very, very seriously, and I don't have to tell you within the healthcare profession or the healthcare area how involved our provinces are involved with that. So we have part of it. We have a very important role to play, but again, I certainly commend the provinces and in many cases the municipalities for what they're doing. In my own area of Niagara, the Regional Health Department is very involved with reaching out to people and assisting them in any way possible.
You are indeed speaking a lot about increasing mandatory minimum sentences, and I think you're aware that all of these measures will result in Canada in us putting many more people in jail for a much longer time. So before tabling these bills that will represent an additional burden, obviously, have you carried out any studies so that we would have some idea, even if it's approximate, of the financial burden that you are going to be imposing on citizens?
of time worrying about the financial implications that are for victims of crime. I've been told it's approximately $70 billion a year that victims in this country suffer, and so I'm very much motivated by bringing in legislation that might get some of these individuals who repeatedly victimize people, getting them off the street. Now, if you're asking me with respect to detaining these individuals, I of course rely on my colleague, the Minister of Public Safety, who has assured me on numerous occasions that we can and will meet the demands on the system. That being said, part of what we did getting rid of the 2-for-1 credit was I had every provincial attorney general, every single one of them, tell me that the 2-for-1 system that had been in existence in this country was clogging up provincial resources. It was costing them money in terms of people delaying, people who were looking for a discount in their sentence. And in one case, the Attorney General of British Columbia told me that he heard of a case the guy didn't even want to have a bail hearing. I can hardly imagine that. Practicing law, as I did in St. Catharines and Niagara Falls, a client who didn't want to have a bail hearing. Why? Because they were racking up 2-for-1 credit. So I was very sensitive to that, and I told provincial attorneys general that I would do my very best to get rid of that practice of 2-for-1 because I had all kinds of sympathy for them, among other things, that this was clogging up provincial resources and it was costing them money. So again, I'm hoping that you'll discover, as I'm discovering, that this has been very well received, and it will benefit everyone within the criminal justice system, including our provincial counterparts.
Thank you. We'll move to Mr. Comartin for 7 minutes.
Thank you, Mr. Chair. Thank you, Mr. Minister and Deputy Minister, for being here. With regards to the funding for the $2.5 million for the investigation of missing persons, will any of that actually be spent this fiscal period? And in effect, what I'm asking, Mr. Minister, is given the length of time, including the year-end break that we'll be having, will any of these agencies be able to get their applications in and approved and actually begin to spend money before the end of March?
It would certainly be my hope on that, Mr. Comartin, and if you like, we will keep you apprised of those, because when my colleague, Minister Ambrose, made this announcement, again, that was sort of always my concern on these things. We want to get the money out the door as quickly as possible, get them to great organizations that make those applications. But I would be pleased, since you've raised an interest on that, to let you know, when they are approved.
Could we have, just for the record, Mr. Chair, could we have the department give us a result sometime after the end of March as to how much of the funds were spent? And if they weren't all spent, how much is remaining?
I would be glad to do that. That's a very reasonable request.
Mr. Minister, if it doesn't get spent, what happens? These budgetary items, do they just fall off the table at that point?
Well, again, they...
I'm sorry, what I'm asking is, can you spend them in 2011-12 period?
Again, we'd have to cross that bridge when we get to it. My determination is that we will spend the money that's allotted to us.
Do you expect to have a similar amount allocated? I'm going to ask you what's going to be in the budgets, what I'm asking you now. Do you expect...
I'm just trying to get past these estimates.
I understand the problem you've got, but will you be seeking a similar amount from the Finance Minister for 2011-12?
Well, again, the Minister of Finance, I'm sure will hear very loud and clear about my concern for victims right across the board, and that will be part of the upcoming budget discussions that we will have with him, Deputy Minister.
If you think it will have any impact on him, I think you can assure him that the rest of the members of this committee would be supporting you in that regard.
This is good.
I might just add, Mr. Chairman, that the budget 2010 figure, the $10 million, was over a period of 2 years. There are certain funds, as you and the Minister were just discussing, that are for this fiscal year only, and those are the funds that are set aside for the Aboriginal organizations looking at public legal education and so on. The bulk of it, the $10 million, is over a 2-year period.
I think the point you were trying to make was, would it lapse if it doesn't get out by March 1st, and this, it will not.
That part of it, okay.
Okay.
There were a couple of newspaper articles, I don't know if they were last week or the week before, indicating that funds, this would be, I think, part of that $10 million, that were not allocated. I think they said as much as 43% had not yet been allocated, and it was not likely that much of that 43% would be allocated. I don't know if you saw those or if you've done any analysis on it, but were those articles accurate?
hesitate to say I didn't see every article about every aspect of ours, but the money is there and it's committed, and we want to see all of it spent in assisting, the whole area of murdered, missing, and murdered Aboriginal women.
Well, it wasn't just on this; it was victims of crime, funds for victims of crime generally.
Again,
so, including some of the other programs.
Yeah. The money is solid and will be available for this coming fiscal year with respect to victims of crime. But sometimes in some of the programs, they're not completely utilized. And part of what we are doing in terms of advertisement is getting the message out to people, say, please make applications, please become aware of this. And indeed, that's one of the matters that I raise with my provincial counterparts when I meet with them on a regular basis, is to do anything they can to make sure victims are aware that these are available, just for the reason that you said.
Mr. Minister, both, and the committee heard this with this last year as we were doing the work on organized crime, and I think we heard it in British Columbia, I know we heard it in Manitoba, and I believe we heard a bit of it in Alberta, that a number of the agencies are finding it very difficult, both with regards to dollars for prevention and dollars for assistance to victims of crime, that the accounting, the accountability, the process they have to go through in spending these monies are beyond the scope and capabilities of a large number, especially of the smaller agencies. I guess so. Two questions. One, have you heard the same complaints? And if so, are you prepared to reassess how much monitoring is going to be required for the spending of these funds?
I mean, we have to be very careful any time you spend funds. I mean, I have to tell you, I mean, the feedback that I have gotten back has been very positive. I mean, I don't, in fact, I've been down as part of the announcements in Prince Edward Island, for instance. I was down there with them in a working arrangements with the provincial government in terms of what they are doing. But if there are individual cases that people say the application is either not being expedited or being slowed down, please feel free to contact my office, and I would be glad to look into that, because I have no stake in making sure these things get bogged down, and we want them to get out and help people, because that's what they're there for. But again, most of the feedback I get is positive.
It's not so much in the application process. It's in the deployment of the services that too much of their time, and therefore those financial resources that you've allocated either to prevention or to victims, is being used on administration in terms of having to monitor the spending of the fund.
To comment on that.
Thank you, Mr. Chairman. So, Mr. Martin, with respect to processes going forward in getting that money spent for the objectives for which it was intended, we're doing a number of things, and one of them does have to do with simplifying processes around accountability. Okay. But in doing that, as the Minister said, we want to reduce the administrative burden on the accountability front while making sure that at the end of the day we've got the information we need. So we are trying to make some efforts that way to see what we can do to assist on the accountability front.
I guess, Mr. Kirwan, the problem I'm having is that I'm hearing from some of these agencies that as much as 20–25% of these dollars are spent by them on administrative staff in terms of preparing the reports, the accounting reports, those kind of budgetary and financial accounting. It just seems to me there's got to be some way of reducing that to 5 or 10%. As opposed, we should be spending 90% plus of these dollars on services, on direct services, rather than on accounting.
The deputy's indicated to me that he's not aware of what that agency are, but if you forward that to me, I would be glad to check into that, because again, we don't want them to be spending all their time, filling out forms or spending time on the administrative side of it as opposed to the program delivery.
Thank you. Thank you. We'll move to Monsieur Petit. 7 minutes. I believe you're splitting your time with Mr.
Oui, je vais dépenser mon temps avec...
Yes, I'll split my time with Mr. Deckert. Thank you, Minister, for having come. What draws my attention is that, having explained all of the bills that we intend to table, you have spoken about something that's very important, and that is the information on victims. We know that we created the Ombudsman Office, which is a great success for us in the Conservative Party, but I'd like you to speak a little bit more about the Victims Information Office that you spoke about in the second half of your comments. I represented the government in several organizations, One Child in Ontario and in another child advocacy group, and it's always the lack of information to help these groups or these children. Children see something on television, say you can call this number on television that's on television to report abuse, but they need information. So can you tell us a bit more about that whole program?
I mean, we've come a long way, Mr. Petit, even in my legal career in terms of handling children. I mean, some of the presumptions and into the criminal system with respect to children, the presumption, for instance, that they're lying or that that they can't be relied on. I mean, I think we've come a long way, and our job is, of course, to assist victims, reduce victimization among children, assist children who get into the criminal justice system, and to give them all the services that they need. I firmly believe that this idea of child advocacy centers, there's about 5 of them across Canada at this point. There's 1 or 2 in the works. It is my sincere hope that this will become the norm in communities across this country, and that they will be that refuge, that resource to assist children who become victims of crime. It can be, I mean, we hear stories all the time of people who say they have become victimized, how terrorized they become, how unfamiliar they are with the system, how foreign this is to them, how difficult it is. And many times you'll hear years later that people are still scarred by the system that they went through when they were children. And so it seems to me with these child advocacy centers that it takes direct aim at the challenges that children face that are involved with the criminal justice system, and like any new idea, the question of funding is always a challenge. And I congratulate and thank those municipalities or other levels of government who have provided some assistance to them. But they, for the most part, tell me that it is a bit of a hit-and-miss process. I mean, that a municipality may give them a grant for 1 year, but then not the next, this sort of thing. So having some sort of stability in that area, I think, is a great step forward. And so, again, I was very, very proud and very pleased to indicate a few weeks ago that the federal government would be providing over $5 million worth of funding in this particular area. It's a step in the right direction, getting the federal government involved with these advocacy centers. They're perfectly consistent with our overall approach in this area, and they address a particular need. And so, yes, I'm quite excited about that. And again, it's certainly my hope that these will become the norm in Canada, and that we won't be limited to these 5 or 6 that currently exist.
Thank you, Mr. Chair. Minister, thank you for telling us a little bit more about the criminal justice legislation that you've introduced in Parliament. You mentioned Bill S6, the repeal of the Faint Hope Clause, which this committee dealt with last week. And I think it's interesting that just today, Clifford Olson, one of Canada's most notorious murderers, appealed for parole again. Now, we know that a few years ago he was denied the right to appeal under the Faint Hope Clause. However, he can still apply because he's gone beyond the 25-year life sentence ineligibility period. The parents of 2 of his victims, Sharon Rosenfeld and Raymond King, were quoted in the media today about the trauma that they go through every time they have to appeal at one of these parole hearings. Can you tell the committee how the families of victims have expressed their displeasure to you with respect to the Faint Hope process?
Well, there certainly is unanimity among these victims who speak with me, and they tell me they start dreading it when the 15 years starts to roll around. they start reliving it. It never goes away from them. They tell me the trauma that they have experienced, but the idea and the fear that that individual might be released after 15 years. And I can appreciate there are statistics that say, for the most part, they don't get out at 15 years. But they all tell me it's the same thing. It's the terror, the horror, the thought that that individual will be back out on the street. And then as soon as they're over that process, they're at the 17-year mark, and of course the 19-year mark over and over again. Some of them tell me, for instance, they believe that the convicted murderer knows that he's not going to get out, that he's not going to pass the test under the faint hope clause. They believe that this is his way of victimizing them all over again, to get one more shot at them, you see? And so they are victimized over and over again. And so, again, my heart goes out to them. And I say, yes, if the individual is convicted of premeditated murder, that they should be waiting 25 years before that. But yes, I do meet with them. Sharon Rosenfeld, you mentioned her, is an outstanding example of somebody who is fighting to change some of the laws of this country that help victimize people. So it's not easy, and I want to see this passed into law. And for once, and it will be applauded by all those who unfortunately have had to go through this process.
Thank you. We'll go to Ms. Jennings for 5 minutes.
Yes. Thank you very much for your presence here today, Minister. And thank you for bringing forth this bill. Discussing with some of my colleagues both in my own caucus and other caucuses and former colleagues in the legal profession, there seems to be an agreement that when the death penalty was first abolished and life sentences with no possibility of parole before 25 years was brought in back in 1996, that the Parliament probably did not consider the possibility of multiple murderers, and whether or not it would in fact be appropriate to allow the judge the discretion to order that the parole ineligibility be served consecutively in the case of convictions for more than one murder. And so I think that this piece of legislation is timely. I do, however, find it unfortunate that, and perhaps you can explain, this bill was first tabled in 2009 and sat at first reading for 64 days. The Prime Minister prorogued at the very last day, I believe it was, of 2009. And we then sat through an 81-day prorogation before the throne speech took place on March 23rd, 2010. And then you and your government did not retable the bill for 216 days. So I think it's unfortunate that for whatever reason, and you may be able to provide this committee and families of victims the reasons for these delays, for not having moved second reading in the last session of Parliament, rather than leaving it there for 64 days, and then once prorogation was over, waiting 216 days before retabling it. But I'm glad that when you finally did table it, you moved second reading fairly quickly, and it's been able to come before this committee quickly.
Just a reminder, we aren't discussing C48 specifically.
Well,
we're talking about the supplementary estimates.
You're correct, Chair.
I will allow general questions. We generally do.
Chair, we weren't discussing S6, and you allowed complete latitude with no recall to the other members. So
I just remind you, because you referred that you referred to a bill, and there's no bill before us. We have the supplementary estimates.
And the minister himself referred to other bills. The parliamentary secretary and another member of the Conservative Party referred specifically to S6 and continued many questions on it. Therefore, I think that my points are not at all inappropriate. It's in direct relations to statements that the minister himself has made here. Now, I have a question. You talked about in your response on S6 the issue of the, if I can use your exact words, the terror and horror that families of victims relive over and over again when convicted multiple murderers apply for the faint hope clause every 2 years or every 2 years from the previous application and refusal. I would then ask, would you be able to provide this committee with a reason why your members would have voted against an amendment to S6, which would have required a mandatory notification to the relatives of victims when an offender did not apply for early parole under the faint hope clause and under the new legislation would not be eligible again for 5 years, and that notification would have also given the family of those victims a notification that, one, the offender did not apply under the deadline, and that the next earliest opportunity would not be until X date 5 years hence, in order specifically to allow those relatives to live a certain amount of time without that stress, without that anxiety that you so well and accurately described.
First of all, just a slight correction of what you said. The faint hope clause is not available for people convicted of multiple murders. It's the one murder. Yeah. Okay.
Yes, I understand.
Just so we know.
I may have misspoke.
I'll tell you my problem with your amendments. And to be fair, I guess you were quite honest. You said you wanted to keep the door open for some possible future government that you might be a part of, that you would like to reintroduce that. I remember. Yeah. I read your comments. You said, "We'll be honest." Isn't that? Yeah, she said, and that's fine. That's your business to do that. But here's what the effect of this. You've changed the name of the bill, and you changed the number of the days. It has the effect of holding up the bill. On the one hand, you started off by saying, "Doesn't the government want to get these things passed?" Yes, I want to get them passed. If you keep amending them, if it goes back to the Senate, and you have some of your colleagues down there make an amendment because they want a small change on it, the thing will never get passed. I'm trying to get these pieces of legislation, get them through. I'd like to get them into the law of this country before Christmas, but if I get 4 or 5 amendments, on the one hand you can tell people, say, "Oh, we're supportive of it. We got lots of amendments. We need lots of studying of these things." It's very difficult.
Minister,
thank you,
Madam Jennings, but fair enough.
We're going to go to Monsieur Lemay.
Point of order. I would just like to point out that the minister did not, in fact, address the specific question about the notification to the relatives of victims of murder.
No, hold on. First of all, that's not a point of order.
That was not answered, and I would like through the chair.
Over 6 minutes.
No, but this, I would like through the chair a request to the minister to provide his answer in writing.
Because we do have votes coming up. Monsieur Lemay?
Chair, this is a point of order.
It is not a point of order.
Chair.
Is it a procedural matter?
It is a procedural matter.
What is that
It's a procedural matter. I have the privilege of asking a question.
Yes, you do.
The minister did not respond to the specific question. I am therefore asking that you as chair to ask the minister to provide his response to the specific question that I asked about the amendment requiring a mandatory notification to the relatives of victims of murder.
Ms. Jennings, it's not a point of order. But
it's a request to you.
We are taking time away from other members because we have a vote coming up in less than 5 minutes.
Will you ask the minister?
No, I will not. I'm going to go to Monsieur Lemay now, and he's going to have his 5 minutes.
Merci. Bonjour, Monsieur le Ministre.
Thank you very much. Good afternoon, Minister. And I'll say to you that I heard everything that you said, and quite obviously we will never be able to support this, and this is why we agree with some amendments. And it's particularly a problem with the short titles that do not respect what the bill says. So I have an example of C-16 that is a bill ending suspended sentences or conditional sentences for violent criminals. But it's not true. That's not what Bill C-16 says. S6 is another example. We voted against it because the short title does not respect what's in the bill. Same thing for C-22. Your parliamentary secretary came to my riding and said that we voted against it. That's not true. We voted against the short title that is completely disconnected from the bill. So now you want to talk about real stories, first of all. On page 181, funds available to support victims of violence and prevention in Aboriginal communities. We're talking about Vote 1 and Vote 5, $2.449 million. To increase the support for these persons who have disappeared. It is a request that has been made by Aboriginal women, and I know about that because I sit on Aboriginal affairs. My question is, will these monies be sent directly to Aboriginal communities, or is this money for police forces to go out and help with the research? Because the problem is the research that needs to be done regarding these victims. So what are those sums exactly?
Things, Monsieur Lemay. First of all, with respect to the short titles, you must have the same thing with people. When people say C-48 or C-15, they don't know what you're talking about. I mean, indeed, people, and so the short titles of bills. I mean, again, you can make a career out of fighting these things, and that's your business.
Avec respect, Monsieur le Ministre.
No, with all due respect, Mr. Minister, you're very strong. I respect you, but I'd really like to have an answer to my question because I only have 2 minutes left. So, and I had another question I wanted to ask after that.
Among other things, this will set up a new national police support system for missing persons. They'll make it possible for every police officer to have the particulars of missing persons reports at hand. They will assist communities develop community safety plans. That will be another aspect of it to increase the safety of Aboriginal women and children. It will help communities compiling a full list of promising practices that communities can adapt rather than starting from scratch. There will be funding for provinces to adapt and develop culturally appropriate victim services for Aboriginal Canadians, as well as funding for Aboriginal organizations themselves and groups to address the unique needs of families of missing and Aboriginal women. As I said to Monsieur Comartin, this will be an ongoing thing, and I would be glad to inform you as to any application that is successfully made.
Et ces sommes d'argent.
All right, and these amounts of money are currently available or will be once we will have supported this?
Yeah, they're in the supplementary estimate. You're right. If the government is defeated, and
Non, on veut pas. Il y a personne ici qui va.
No. No one around this table wants to trigger elections. No. No one here wants elections. Apart from perhaps a few here, but in any case. This is the same thing I imagine for the victims of crime through this enhanced creation and enhancement of child advocacy centers across Canada. So the question I have is the same. In Quebec, for example, I was talking about the allocations here. In these youth centers, will it go directly to the centers, or is it totally a totally new center, this advocacy center? Is it for the Federal Victims Center? So who's going to benefit from these sums, which are so important for victims?
Able to make that application directly to the federal government for direct funding. It's not funding that, as sometimes happens, goes through the province and then people apply to the province. If there is a child advocacy center that wants to get started up in your riding, or if there's an existing one, it can make the application. We want to make that as quickly as possible.
Thank you. Thank you. You have before you the estimates. There are 1, 2, 3, 4 votes that customarily are called on this. Would someone like to make sort of an omnibus motion to deal with all 4 of them in one? Mr. Deckert? That would be vote 1B under Justice, vote 5B under Justice, 30B and 35B under Justice. So I'll call the question on that, seeing no debate. Shall those 4 votes carry? Yes. All right. On division? Shall I report the supplementary estimates B 2010 to 2011 to the House? Yes. Yes? Thank you. We're adjourned.